Let me start by speaking directly to you. If you're a United States citizen or a lawful permanent resident who wants to bring your spouse, your parent, or your child to live with you here in America, you've probably seen the headlines. Maybe you've read something like 2026 income requirements skyrocket, or new financial barriers could deny your family's green card. And I understand completely if those words made your heart sink a little bit. I understand if you felt a wave of worry wash over you, especially if you're retired, or if you're living on a fixed income, or if you're simply not earning what you used to earn. But here's what I want you to know right from the start. My goal today is not to scare you, but to explain these new numbers calmly and truthfully. Because when you understand how the system actually works, you'll see that the 2026 income threshold is not a wall, it's a benchmark. And there are legal, legitimate ways to meet that benchmark, even if your paycheck alone doesn't quite reach it. So let's take a breath together, and let me walk you through this step by step, the way I would if we were sitting down over a cup of coffee. Before we go any further, I do want to offer a quick but important disclaimer. Nothing I share with you today is legal advice tailored to your specific situation. Immigration law is deeply personal, and every family's circumstances are unique. What I'm giving you here is general educational information to help you understand the landscape, to help you ask the right questions, and to help you feel more confident as you move forward. If you have a complicated case, if you have prior immigration issues, or if you simply want someone to review your documents before you file, please consult with a licensed immigration attorney who can give you advice based on your individual facts. That said, let's dive in. So what exactly are we talking about when we say the 2026 financial threshold? Every year, the United States government updates what's called the Federal Poverty Guidelines. These guidelines are issued by the Department of Health and Human Services, and they're used across many different programs to determine eligibility for benefits, assistance, and yes, immigration sponsorship. When you sponsor a family member for a green card, you're required to sign a legal document called the Affidavit of Support, or Form I-864. And on that form, you're making a promise. You're promising the U.S. government that you will financially support your relative so that they do not become what the law calls a public charge. In other words, you're saying, I will make sure my spouse or my parent or my child does not need to rely on government welfare programs. To prove that you can keep that promise, the law requires you to show that your household income is at least 125% of the Federal Poverty Guideline for your household size. For active duty military members sponsoring a spouse or child, that number drops to 100%, but for everyone else, it's 125%. Now, for the year 2026, the poverty guideline for a household of 2 people in the continental United States is $20,440. And 125% of that amount is $25,550. So if you're sponsoring just one person, your spouse for example, and you live together as a household of 2, you need to show that your annual income is at least $25,550. If you're sponsoring more than one person, or if you have other dependents living with you, that number goes up. For a household of 3, you'd need to show income of at least $32,188. For a household of 4, it's $38,825, and so on. These numbers might sound high if you're comparing them to previous years, and yes, they have gone up. But here's the context that often gets left out of those scary headlines. This is not a punishment. This is not the government trying to make it harder for families to be together. This is simply a cost of living adjustment. The price of rent has gone up. The price of groceries has gone up. The price of healthcare has gone up, and so the poverty guidelines go up to reflect that reality. The 2026 numbers are simply a new benchmark, not a barrier. But let's say you're sitting there right now, and you're thinking, I don't make $25,550 a year. I'm retired, and I'm living on Social Security. Does that mean I can't sponsor my spouse? Or maybe you're thinking, I work part-time and my income is closer to $20,000. Am I out of luck? The answer is no, you are not out of luck. And this is where I want to slow down and really explain the safety nets that are built into this system, because they exist for exactly this reason. The law understands that not everyone has a high salary. The law understands that people retire, that people get sick, that people take care of children or aging parents and can't work full-time. And so the law provides alternatives. The first alternative is to use your assets. If your income alone doesn't meet the threshold, you can add the value of certain assets to help you qualify. Now, the rules here depend on who you're sponsoring. If you're sponsoring your spouse or your unmarried child under the age of 21, and you are a U.S. citizen, then you can use assets at a conversion rate of 3-to-1. What does that mean? It means that for every $3 in assets you have, the government will count it as $1 of income. So let's say you're $10,000 short of the income requirement. You would need to show $30,000 in qualifying assets to make up that difference. What counts as a qualifying asset? It could be money in a savings account. It could be the equity in your home. It could be the value of a car that's paid off. It could be stocks or bonds. The key is that the asset has to be something you can convert into cash within 1 year without causing extreme hardship. You can't count your retirement account if there's a huge penalty to withdraw it early. You can't count your grandmother's antique jewelry unless you're actually planning to sell it. But if you have real, accessible assets, they can help bridge that gap. The second alternative, and this is the one that many families rely on, is to use a joint sponsor. A joint sponsor is someone else who is willing to sign a separate affidavit of support on behalf of your family member. This person has to be a U.S. citizen or a lawful permanent resident. This person has to be at least 18 years old, and this person has to meet the income requirement on their own, based on their own household size. The joint sponsor does not have to be related to you. It could be your adult child. It could be your sibling. It could be a close family friend. The important thing is that they're willing to take on the legal responsibility of supporting your relative if necessary. And yes, this is a serious commitment. The joint sponsor is signing a legally enforceable contract, but it's also a pathway that has allowed countless families to reunite even when the petitioner's income alone wasn't enough. So if your income is below $25,550 and you don't have sufficient assets, finding a joint sponsor is a completely legitimate and very common solution. It is not a loophole. It is not cheating the system. It is using the system exactly as it was designed to be used. Now, I also want to address something that's been swirling around in the news lately, especially in February of 2026. You may have heard about visa pauses, about changes in enforcement, about new policies coming out of Washington, and I want to be very clear with you. The path for immediate relatives, meaning spouses of U.S. citizens, parents of adult U.S. citizens, and unmarried children under 21 of U.S. citizens, this path is different from other immigration categories. Immediate relatives are not subject to annual visa caps. There is no numerical limit on how many immediate relative green cards can be issued each year. That's what makes this category so stable. Yes, processing times can vary. Yes, there can be delays at USCIS or at the National Visa Center. Yes, there are background checks and medical exams and all of the administrative steps that take time. But the legal framework itself, the ability to sponsor your spouse or your parent or your young child, that remains protected. That remains a cornerstone of U.S. immigration law. So when you see headlines about visa pauses, in most cases those are referring to other categories, like employment-based visas or diversity visas or refugee admissions. The immediate relative category is separate, it is foundational, and it continues to move forward. Let me also talk for a moment about the practicalities of actually filing your petition. The two main forms you'll be working with are Form I-130, which is the petition for alien relative, and Form I-864, which is that affidavit of support we've been discussing. The I-130 is what establishes the family relationship. You'll submit things like your marriage certificate, your birth certificate, proof that any prior marriages were legally ended, photos of you and your spouse together, evidence of a bona fide relationship. The I-864 is what establishes your financial ability to support your relative. You'll submit your most recent tax returns, usually the past 3 years if you have them. You'll submit recent pay stubs if you're currently employed. You'll submit a letter from your employer verifying your job and your salary. If you're self-employed, you'll submit business records and profit and loss statements. If you're using assets, you'll submit bank statements, property appraisals, vehicle titles, things like that. And if you're using a joint sponsor, That person will submit their own I-864 with their own financial documentation. It sounds like a lot, and it is. But the key is organization. Make copies of everything. Label everything clearly. Follow the instructions on the USCIS website. Double-check that you've signed every form in the right place. And if you're not sure about something, get help. There are non-profit organizations that offer low-cost or even free assistance with family-based petitions. There are immigration attorneys who will do consultations to review your documents before you file. You don't have to do this alone. As for timelines, I want to set realistic expectations. As of early 2026, processing times for I-130 petitions can range anywhere from several months to over a year, depending on the service center handling your case and the specific country your relative is coming from. If your spouse or parent is already in the United States and is eligible to adjust status here, that can sometimes be faster than consular processing abroad. But if they're overseas, you're looking at additional time for the case to move through the National Visa Center, for the interview to be scheduled at the U.S. Embassy or consulate, and for the visa to be issued. These are not quick processes, but they are processes that thousands of families go through successfully every single year. And the wait, as painful as it is, does come to an end. I know this is a lot to take in. I know that if you're watching this video, you're probably in the middle of a very emotional time in your life. Maybe you're newly married and desperate to bring your spouse home. Maybe you're a naturalized citizen who finally has the legal ability to bring your aging mother or father to live with you. Maybe you're worried about money, worried about paperwork, worried about making a mistake that could cost you months or even years. I want you to know that those feelings are completely valid. But I also want you to know that this process, while complex, is navigable. The $25,550 income requirement for 2026 is real, but it is not a dead end. You have options, you have assets, you have joint sponsors, you have legal pathways that are designed to help families stay together. And if you approach this with patience, with preparation, and with the right information, you absolutely can succeed. So take a deep breath. Gather your documents, reach out for help if you need it, and remember that you are not alone in this journey. Millions of families have walked this path before you, and millions more will walk it after you. If you found this video helpful, or if you still have questions, please leave a comment down below. I'd love to hear where you are in your sponsorship process and how I can support you. Thank you so much for watching, and I wish you and your family all the very best.